Today, a majority of people have cell phones, and a near majority of people have smartphones. Should we expect that legal services delivery, legal systems, and the law will continue to remain the same when the world is evolving to be more and more digital? We should be asking ourselves, what will the rule of law look like in a digital world? Now, as we walk through this, let's return to the idea of the lawyer and the legal professional and the services they deliver. Baker McKenzie lawyer Daniel Beneke wrote a very interesting article about machine learning-enabled judgment and the law firm of the future. She observed that lawyers provide four key things: information, labor, prediction, and judgment. Information is less and less of a valuable thing that lawyers can provide. Maybe before the internet, the lawyers had the books, they had information, and it was difficult for other people to get it. Lawyers provide labor on different matters, but often that's not the highest value thing that the lawyers provide. Lawyers make predictions, lots of predictions, and then lawyers provide judgment. And as Daniel Beneke noted in her article, for the first three of these things, information, labor, and prediction, artificial intelligence is already making significant inroads. What about when we turn to thinking about legal systems, such as courts? More and more jurisdictions around the world are thinking about how to use artificial intelligence in courts. There have been headlines, for example, about Estonia using AI and saying AI can be a fair judge in court. We can also look at the ways in which courts are being redesigned. And rather than just thinking about how we can use AI to do the things that we've always done, but how might we redesign the system? Instead of thinking about using AI to replace the judges, what if the justice system focused on the parties to a dispute, for example? This is exactly the type of change enacted in the Civil Resolution Tribunal in British Columbia. There, they use rules-based systems to guide the parties through a process of learning about their rights, learning about their obligations, learning about the other party's perspective on a dispute, and aiming on mediating and resolving that dispute, not just adjudicating the dispute and saying one person is right or one person is wrong. Interestingly enough, lawyers are not involved in the British Columbia Civil Resolution Tribunal. This is all about the parties being guided to a resolution, and there can be adjudication at the end of the process if they're not able to reach a resolution. So we're seeing many more courts around the world use different online versions of courts, online dispute resolution, and so on. One of the obstacles to improving access to law and legal analysis is the law itself. And there's been more and more work being put into thinking about how we might represent the law differently. Could we represent the law as code? So we've seen things like computable contracts or smart contracts, or thinking about how to formalize different laws like tax codes. When we think about code as law, one of the realizations is that more and more people's rights, obligations are determined by the code that's running on platforms and in products and in different systems. Do we need law that essentially functions like code and is closer to where the action is happening? This is a really important question. And to the extent to which we can formalize law, we can represent it as code, could we make it more accessible for people? One of the challenges is for these people who have a smartphone to really be able to understand what the law means and how it applies to them in certain situations. If we can write law in a more formalized manner that is easier to process, easier to apply computation to, could we solve part of that problem and do a better job of helping people understand their rights and obligations at all times? Now, some have worried about the different problems that could arise with things like smart contracts and law as code. One scenario I've heard is that when we have Internet of Things devices, then landlords will be able to do things like put a lock on a front door, and at any time just click a button and lock someone out of their home. But if we really think about if that's a problem, we could think about all the countermeasures and the way in which law could actually work at the source and protect people in situations like that. If code was embedded in these smart locks, for example, what if we required an order of the court, a digital order of the court, before a landlord could lock someone out of their apartment? One of the bigger takeaways here is that we should be really rethinking again what democracy, human rights, and the rule of law looks like in a digital world and with rising artificial intelligence technology. We should be thinking about how we can proactively design innovation processes and platforms, systems, and products to incorporate democratic principles, human rights, compliance, and the rule of law by design and default.